A Supreme Court decision just came down that could determine whether you spend the next decade in a federal prison or walk freely with the firearm you have every legal right to carry. If you are one of the millions of Americans who believe a concealed carry permit is a blanket pass when you cross state lines, you need to stop what you are doing and pay close attention to what I am about to tell you. Because right now, the legal ground is actively shifting beneath your feet. We are not just talking about a single ruling from a few years ago. We are talking about a cascading series of court decisions, new state laws designed to trap even the most careful gun owners, and a constitutional battle that will define the Second Amendment for the next generation. And the consequences are not abstract. We are talking about real-world impact, where you can carry, whether you can be denied a permit, how courts now evaluate every gun law on the books, and what happens if you make one wrong assumption crossing a state line. Headlines are getting this badly wrong. Some are celebrating like every permit restriction in America just evaporated overnight. Others are claiming nothing really changed. The truth lives somewhere in the middle, and the details are the difference between staying legal and becoming a felon. So let us start with what actually happened. In 2022, the United States Supreme Court issued its landmark decision in New York State Rifle and Pistol Association versus Bruen. That case directly challenged New York's concealed carry licensing system. At the time, New York operated under what is called a may-issue framework. That meant even if you passed your background check, completed every required training course, paid every fee, submitted your fingerprints, and had absolutely no criminal history, the state could still deny your application. Why? Because you failed to demonstrate what they called proper cause. Let that sink in. You had to prove to a government official that you had a special, elevated need for self-defense that placed you above the average citizen. Wanting to protect your family was not automatically enough. Living in a high-crime neighborhood was not automatically enough. Working late hours in a dangerous area was not automatically enough. The system was entirely subjective. It was discretionary. And in practice, that meant ordinary law-abiding people were routinely denied, while those with political connections or wealth found the process far more accommodating. The Supreme Court looked at that system and said it violated the Second Amendment. Full stop. But here is why this ruling was far bigger than just fixing one state's permitting process. The court did not simply say New York's rules were too strict. It fundamentally changed the legal test that every court in the country must now use when evaluating gun laws. Before this decision, judges were applying what is called a balancing test. They would weigh the government's interest in public safety against your constitutional right to bear arms. And under that framework, courts often deferred to lawmakers, upholding restrictions by reasoning that public safety concerns justified modern regulations. The Supreme Court threw that framework out entirely. Instead, the court established what is now called the history and tradition test. If a gun law is challenged, courts must determine whether that regulation is consistent with the nation's historical tradition of firearm regulation going back to the founding era. In plain language, if there is no strong historical precedent from around 1791 when the Bill of Rights was ratified, or 1868 when the 14th Amendment extended those protections, then that modern restriction is on deeply shaky constitutional ground. That is a seismic shift, and it immediately set off a legal chain reaction that is still accelerating right now. Before we go any further, understand what this ruling did not do. It did not eliminate concealed carry permits. It did not create nationwide permitless carry. It did not wipe out every gun regulation in America overnight. What it did was eliminate subjective arbitrary discretion in may-issue states. If your state requires a permit to carry concealed, that requirement can still legally exist. But if you meet objective criteria, the state must issue you that permit. They cannot deny you simply because a bureaucrat decided your personal reasons were not compelling enough. That distinction is critical, and it is the distinction that the states which lost this fight immediately started working around. Several states that previously operated under may-issue systems moved quickly after the ruling. On paper, they complied. They removed the proper cause language. They shifted to shall-issue frameworks where permits must be granted when objective standards are met. But here is where things get dangerous for gun owners who are not paying close attention. While one door was closing, other doors were being quietly reinforced. Some of these states dramatically expanded the list of what they call sensitive places, meaning locations where carrying is prohibited even if you hold a valid permit. And we are not talking about courthouses and schools, which have well-established historical precedent. We are talking about parks, public transit systems, restaurants that serve alcohol, entertainment districts, playgrounds, museums, and in some cases, entire commercial zones and city blocks. In New York, there were proposals to designate Times Square and surrounding areas as a sensitive place, essentially making the permit useless in one of the most populated parts of the state. The practical effect is exactly what critics argued. Yes, it may now be easier for law-abiding citizens to obtain a permit in those states, but the list of places where you can actually exercise that right has been so aggressively expanded that in some jurisdictions the permit is effectively a piece of plastic that only functions in your own driveway. And then there is what some legal experts are calling the vampire rule, and this one should genuinely alarm you. Traditionally, the default assumption in most states has been that you are permitted to carry on private property unless the owner posts a sign saying no firearms. These states flipped that assumption entirely. Under this approach, you are presumed to be committing an offense unless the property owner has specifically posted a sign indicating that firearms are welcome. That means every gas station, every grocery store, every local business you walk into without that specific signage becomes a legal trap. You might be in full technical compliance with your permit and every training requirement and still be committing a crime because a coffee shop owner never put up a sticker. This is the environment gun owners are navigating right now. And courts across the country are divided on whether these state responses are themselves constitutional under the very test Bruen established. Some federal judges have temporarily blocked the expanded sensitive place designations, ruling that they effectively nullify the right to carry in public. Others have allowed those same restrictions to remain enforceable while litigation continues. That creates a dangerous gray zone where a law can be questioned in another district but still carry full criminal penalties in yours. Here's a scenario that illustrates exactly how this plays out in the real world. Imagine you live in a state that rewrote its carry law after the Supreme Court's decision. You go through the new shall issue process, you pass your background check, you complete your training, you receive your permit, you believe you are fully compliant, but your state has also expanded its sensitive place restrictions to include a venue you visit regularly. You carry there believing that an article you read indicated a federal judge questioned a similar restriction in another state. The problem is that until a final ruling is issued specifically in your jurisdiction and all appeals are fully exhausted, that restriction may still be completely enforceable. Your good faith belief about a case from another circuit is not a legal defense. This is precisely why staying current on your specific state laws, not generalized summaries and not headlines, is a legal necessity and not just a hobby. Now let us talk about the broader legal battlefield, because this ruling touched far more than just concealed carry permits. Under the new history and tradition test, courts across the country are now evaluating challenges to magazine capacity restrictions, bans on certain rifle configurations, age-based purchase limits for adults between 18 and 21, waiting periods, firearm licensing schemes, micro-stamping requirements, and bans on what the government calls assault-style weapons. Some of these laws are failing that scrutiny, others are surviving it. The outcomes depend heavily on which federal circuit you are in, and right now circuits are reaching different conclusions on very similar questions. On the question of so-called assault weapon bans, there are an estimated 25 to 30 million AR-15 style rifles currently in circulation in the United States. Under the standard established in prior Supreme Court precedent, if a firearm is in common use by law-abiding citizens for lawful purposes, the government faces an extremely high bar in prohibiting it. Courts are actively wrestling with how Bruen's history and tradition test interacts with that common use framework. Some circuits have upheld state bans, others are facing significant legal pressure to strike them down. If you live in a state with an assault weapon restriction, you are currently living in a state of genuine legal uncertainty. There is also a recently decided case that anyone interested in home builds needs to understand. The Supreme Court ruled on the question of so-called ghost guns, those unserialized firearms assembled from commercially available parts kits. The court determined that federal regulators have authority to treat certain weapon parts kits as firearms, subject to serialization requirements under existing law. The core reasoning was that if a product is readily convertible into a functioning firearm, it qualifies for regulation as one. This effectively ended the unserialized new build era. Claiming ignorance of this development is not a viable legal defense going forward. Now let us address the issue that causes more real-world legal trouble than almost anything else, and it is an issue this ruling did absolutely nothing to resolve: interstate reciprocity. The Bruen decision did not create national carry recognition. It did not force states to honor each other's permits. It did not function like a driver's license system where your credential is valid everywhere. Reciprocity between states remains a patchwork of individual agreements, and some of the most heavily populated states in the country, including New York, California, Maryland, and Hawaii, recognize very few or zero out-of-state permits. There is currently legislation in Congress that would establish national reciprocity, essentially requiring states to recognize permits issued by other states the way they recognize driver's licenses. As of now, that bill has not become law. which means if you drive from a state with favorable carry laws into a restrictive state without thoroughly researching the current reciprocity situation, you are not just a visitor who made an innocent mistake. You are a target for prosecution, and the penalties can include felony charges, firearm confiscation, and permanent loss of your right to own firearms. People have been pulled over for broken taillights, disclosed a legal permit from their home state, and ended up in handcuffs because the state they were passing through does not recognize that permit. This is happening right now. It is not hypothetical. This is why oversimplified headlines genuinely cause harm. When someone reads that the Supreme Court expanded gun rights and interprets that as universal deregulation across all 50 states, the consequences can be life-altering. So where does all of this leave you practically? The ruling was unquestionably significant. The elimination of subjective discretionary denial systems was a real and meaningful development in Second Amendment jurisprudence. It affirmed that constitutional rights cannot depend on whether a government official personally finds your reasons compelling. That principle matters, and it marked a genuine shift in the balance between bureaucratic discretion and individual liberty. But constitutional victories do not automatically translate into uniform, real-world change. States are actively pushing back. Lawmakers are drafting new legislation specifically designed to test the limits of what Bruen permits. Advocacy organizations on both sides are funding ongoing litigation. Courts at every level are interpreting this ruling in different ways, and the Supreme Court itself may need to step in again to clarify exactly where the constitutional line sits. We are in a transitional period where the scope of the Second Amendment is being actively defined in real time. There are several concrete steps you need to take right now to protect yourself in this environment. The first is to understand your specific state's current framework, not what it used to be, not what a social media post says, but what is actually enforceable today. Statutes change. Emergency rules are enacted. Court injunctions can pause enforcement and then lift months later. The law you read about 6 months ago may not be the law in effect today. The second is to know whether your state has a default carry or default no carry rule for private property. If your state has adopted a version of the vampire rule, you need to understand exactly what signage requirements exist and what constitutes a legal carry location versus an unintentional offense. The third is to verify reciprocity before crossing any state line with a firearm every single time, not using a map from a forum post years ago and not relying on memory from the last time you checked. Agreements change. Use a current, reliable source or consult a firearms attorney before you travel. The fourth is to know your sensitive place list cold. Even with a valid permit, federal facilities, post offices, courthouses, and in many states, any establishment serving alcohol are absolute no-go zones where one mistake is a felony. The fifth is to consider joining a legal defense network. In this environment, even if you are completely in the right, the cost of proving it in court can be financially devastating. Having qualified legal support on call is increasingly a practical necessity rather than an optional upgrade. The Supreme Court's decision reshaped the constitutional framework. It rejected the balancing test. It established that gun laws must be grounded in historical tradition rather than modern policy preference. It empowered challenges to a wide range of existing regulations, and it set off a nationwide legislative and legal response that is still accelerating. But it did not erase all restrictions. It did not create a uniform legal landscape across 50 states. It did not end the debate. What it did was open a new phase of that debate, one being fought simultaneously in legislatures, in federal courts, and in the practical daily decisions of millions of gun owners trying to stay on the right side of an evolving and often contradictory legal landscape. The ruling was significant, but the story is still being written, and what gets written next will depend on how informed and how prepared the people navigating these laws actually are.